A federal judge in Chicago saying Cook County's gun ban is legit, as you've got the Southern District of Illinois moving forward with schedules to have the case heard on the merits of the statewide gun and magazine ban. Welcome back. Bishop on Air here each and every weekday morning with you. I'm Greg Bishop. Thanks for taking time and joining us. And like, subscribe, hit that notification bell. And let's get right on into this with the Southern District of Illinois case. We monitoring that for months, ever since the gun and magazine ban statewide was implemented way back in January of 23. So you've got that case that's continuing on the merits, right? And this is for the statewide ban. But what about the Cook County ban? Firearms Policy Coalition, they have a breakdown of the latest in that case, which actually, if you look at their website for this, they've got Viramontes versus Cook County. It's a Second Amendment challenge to Cook County's, quote, assault weapons ban. And it's fascinating because this thing was filed way back, if you scroll all the way down, in August of 2021, challenging the Cook County ban on certain semi-automatic firearms. And you can see where all of this comes out, and the complaints filed, and all of the discovery, and so on, with a variety of different filings, all the way up till Friday, where the order on the opinion was issued, and that federal judge essentially keeping Cook County's ban in place. And Firearms Policy Coalition really boiling it down for people to better understand where exactly this is and where it stands in the federal court. It says, legal update, the judge in our lawsuit challenging Cook County's assault weapons ban upheld the ban today, saying a gun that can shoot at a third the speed of an M16 isn't different enough from the latter to render them subject to Second Amendment protection. Let's just go ahead and read what they've isolated out here. This is truly a distinction without a difference, the judge wrote. Beavis, the case where Robert Beavis is challenging the city of Naperville's ban, which a federal judge has upheld, essentially on preliminary actions, with Beavis and several other plaintiffs going to the U.S. Supreme Court to get them to intervene. But back to the judge here in the Viramontes case, they say Beavis made clear that the relevant distinction is how fast the AR-15 shot in isolation, but how its firing rate compares to that of an M16, which, as recognized in Heller, was appropriately subject to regulation. And again, this is the Viramontes judge reflecting on the Seventh Circuit Court of Appeals case in Beavis, essentially pointing to that in their ruling that was issued on Friday. It goes on to say that we do not rule out the possibility that the plaintiffs will find other evidence that shows a sharper distinction between AR-15s and M16s than the present record reveals. By the court's math, pre-modification with bump stocks or other devices, the AR-15 shot around 40% as many rounds a minute as did the M16, 300 versus 700. The difference is similar, though. Using plaintiff's numbers, if the M16 can effectively shoot at 150 to 200 rounds a minute, and the AR-15 can, pre-modification, shoot at 45 to 65 rounds a minute, then the AR-15 can shoot about 33% of as many rounds in a minute as an M16 does. This is no indication in Beavis that this percentage difference in minute-to-minute firing capacity would render AR-15s different enough from M16s, which the court assumed were military weapons, to render them subject to Second Amendment protection. So there you've got the federal judge in that case, and that case is now closed in district court there in federal court. So Viramontes being on subject the final order, which is essentially saying, hey, this case is done in the district court, summary judgment. So now I'm guessing they can go to the appeals court in the Seventh Circuit and then get a record there and then head up to the U.S. Supreme Court. But you've got other cases in front of the U.S. Supreme Court when it comes to the gun bans, that not just statewide, but also locally, Cook County, Naperville, and so on. So we'll be watching that closely as well. But again, the Seventh Circuit Court of Appeals case that was heard on the Southern District case, that was only on preliminary grounds, not on the merits. And that's why the Southern District Court in Illinois is going forward on the merits. And on Friday, Judge Stephen McGlynn in the Southern District, he set and reset deadlines and said that action is due by March 13th. So March 13th, that's coming up just around the corner, so we'll see some filings there. But also you've got the expert witness list that's due from the litigants by March 27th. So that's in the Southern District on the merits of the statewide gun ban, while on Friday you also had Cook County's gun ban upheld by a federal court. So just some of the latest in litigation over bans in the state of Illinois. But the Firearms Policy Coalition also posted some interesting things, kind of raising questions of some of the talking points that there are. And in particular, they highlight a text or a chat tweet, whatever we're calling it now, from Giffords, gun control advocacy group. It says, breaking, 6 conservative Supreme Court justices just issued a ruling in NYSERPA v. Bruin that will make us all less safe as gun violence has reached historic high. This ruling imposes the gun lobby's dangerous guns everywhere agenda on all of us. And again, this was from June of 2022 when the U.S. Supreme Court issued that ruling in NYSERPA v. Bruin. That's the New York State Rifle and Pistol Association v. Bruin, that a lot of people say really kind of reset the deck on how courts are to deal with Second Amendment challenges of gun regulations. But then Firearms Policy Coalition, they then share another tweet from Giffords saying MAGA Republicans doing everything they can to ignore the fact that violent crime is actually down in most cities as of 2022. The fact might hurt, but they're still the facts. So, the FPC just simply saying, looking at these two different tweets about historic levels of gun violence, but yet gun crimes are down. I thought Giffords essentially intimated that because of NYSERPA v. Bruin, crime was going to go up. So FPC just simply saying, So interesting again to see some of these arguments made, and we'll be tracking all of this closely for you. Here with Bishop on Air. Be sure to like, subscribe, hit that notification bell. Join us each and every weekday morning as we do these programs to keep you updated and informed of what's going on in and around this particular space. All right, so again, bishoponair.com. You can find how to contact me and all the various social links, X to Facebook and beyond. So appreciate you guys being here each and every weekday morning.